Summary Convictions Court is part of the Provincial Court of Manitoba. The majority of the cases heard are Highway Traffic Act offences, but the court also hears all other Provincial Act offences, as well as federal statute offences and various municipal bylaws. These cases are heard at courthouses throughout the province and are presided over by a judicial justice of the peace or a judge. Most cases will begin with an offence notice issued by a peace officer. An offence notice is often referred to as a ticket. If you receive a ticket, you should carefully read all of the information. Important information about your options and obligations will be included on the front and back of the ticket. You will have three options. Plead guilty by voluntarily paying the fine if one is shown on the ticket. If there is no fine amount on the offence notice, this option is not available to you. Appear personally at a court office to plead guilty and explain any extenuating circumstances that you would like the court to consider, or plead not guilty and set a trial date. These options will be explained in more detail shortly. It is important to respond by the final response date or due date shown on the ticket, or you may be default convicted and you will be required to pay an additional penalty of $50. In some circumstances, a warrant for your arrest may be issued to compel you to appear before the court to answer to the charge. Option 1. Plead guilty by voluntarily paying the fine. If a fine is shown on your ticket, you may pay online, by mail, in person at a Manitoba Court Centre, or by phone. The information on your ticket will explain more about available payment options and where to send your payment. If you are voluntarily paying the fine, you are acknowledging that you are guilty of the offence that is the subject of the ticket. Please be aware that this may result in other penalties which are outside of the court's control, such as demerit points or driver's license suspension by Manitoba Public Insurance. You may not be able to pay in person or online before the response date on your ticket. You can mail in your payment along with a copy of your ticket before the response dates, but you must ensure your payment will be received in the court office before the final response date on your ticket. Option 2. Go to a court office to plead guilty and explain any extenuating circumstances that you would want the court to consider. You may go to the Summary Conviction Court Office at 373 Broadway in Winnipeg, or to any regional court office between the response dates indicated on your ticket if no fine is shown on your ticket, or if you want to plead guilty but would like to speak to a justice about the fine amount or request time to pay. Court offices are open Monday to Friday from 8:30 a.m. to 4:30 p.m. and are closed on weekends and holidays. Some regional court locations may also be closed between noon and 1 p.m. on weekdays. If you want another person to plead guilty on your behalf, you must give them your written authorization to do so. For photo enforcement tickets, the registered owner should complete the authorization on the back of the ticket. If the registered owner is a company, the court will require that written authorization be on the company letterhead, or that the person bring proof of their authority, such as a copy of the Articles of Incorporation. Representatives should be prepared to show identification, such as a driver's license or passport. If you authorize another person to plead guilty on your behalf, you will still be responsible for payment of any fine or other penalty that the court may order. Pleading guilty means that you admit the offense you were charged with, but that there were circumstances that you believe should warrant a lower penalty. You will be found guilty, and you will be given an opportunity to explain any extenuating circumstances that you would want the court to consider. You may ask the court to reduce the fine, or you may request additional time to pay. Option 3. Plead not guilty and set a trial date. Pleading not guilty means that you do not admit to the offense you were charged with. If you plead not guilty, a trial will be scheduled and you will be required to return to court on another date. You may appear and act personally or by representatives at the trial. If you want a lawyer or paid agent to represent you, you should arrange for one before you set a trial date. If you want another person to appear or act on your behalf, you must give them your written authorization to do so. You or your representative should be prepared to produce identification, such as a driver's license or passport. If another person acts on your behalf and you are found guilty, you will be responsible for payment of any fine or other penalty that the court may order. If you do not appear for your trial, a warrant may be issued for your arrest, or the trial may go ahead without you, and you may be found guilty of the offense you were charged with. If you will be unable to go to court, or to send a representative to appear on your behalf on the scheduled date, you must contact the Crown Attorney's office as soon as possible before the scheduled date. On the day of your trial, you should plan to arrive at least 30 minutes before the time indicated on your trial notice, and you should be prepared to be at the courthouse for up to 3 hours, as there are often many matters set for hearings on trial dates. In the courtroom, all cell phones, pagers, and electronic devices must be turned off, and no food or cameras are permitted. You should also be aware that the wearing of hats is not allowed. Courts are open to the public, and you can expect other people to be present when your trial is taking place. On your arrival at the courtroom, you must check in with the Crown Attorney, who will confirm your plea and may provide you with documents or discuss other matters relating to your case with you. Prior to court beginning, the Crown Attorney will explain the difference between the pleas of guilty with an explanation and not guilty. It may be that your discussion with the Crown Attorney will lead them to recommending a lower fine, a reprimand, or a staying or dropping of the charge depending on the circumstances or facts of the case. You should show the Crown Attorney any documents or other evidence you plan to use in your defense, such as photographs or maps. If you have arranged for witnesses to be in court to testify on your behalf, you must tell the Crown Attorney so the matter may proceed in an orderly fashion and follow the rules of court. When your name is called, you must tell your witnesses to wait outside of the courtroom until they are called in to testify. You will be directed to be seated at a table across from the Crown Attorney at the front of the courtroom. The Crown will present their case to the court first and will often have a police officer or other witness testify. This may not be the case with some photo radar cases. Where witnesses are called, they will be asked questions about the incident by the Crown Attorney, and then you will be given an opportunity to cross-examine the witnesses if you want to do so. Cross-examination simply means that you will be able to ask them questions that are relevant to the details of the case. You may be permitted to show the witnesses your documents, photographs, or other evidence and ask them questions about that evidence while you are cross-examining them. After the Crown Attorney has finished presenting his or her case, you may call any witnesses you have waiting outside the courtroom. When your witness is testifying, you will ask them questions first, and when you are finished, the Crown Attorney will be permitted to cross-examine them. You may choose to testify on your own behalf, but you are not required to do so. If you do choose to testify, the Crown Attorney will be permitted to cross-examine you. Any documents, photographs, or other evidence you want the court to consider must be given to the court clerk while you are testifying. After all of the witnesses have testified, the Crown Attorney will make a speech to the court. This speech is referred to as a closing argument. After the Crown is finished speaking, you will be given an opportunity to present your own closing argument, summing up the reasons why the court should find you not guilty of committing the offense you were charged with. After you are finished, the court will make its decision, and you will be provided with any necessary instructions or documents before you leave the courtroom.